Welcome to today's webinar. Today, there is a very important topic I would like to discuss with all of you. You all are going to become a lawyer, and definitely you are going to impact the society around you. And the most heinous crime against a daughter or a lady or your friend, female friend, I would like to tell you, and your wife, your sister, your mother will be a rape. And this word itself is so heinous, like it puts so much societal pressure sometimes that many of the rape cases are not even reported. Nowadays, the reporting has been more because of the society somewhere, I would say, accepted that if there is a rape, there has to be a punishment, and it is not a stigma to that person, that lady, but a stigma to our society as a completely. And that family is supported. Like we all remember Nirbhaya case of 2012 December. That day in the Indian history, I would call it a black day because six people raped that girl in front of her friend. And Delhi being capital of India, the whole nation and in fact international coverage was like it was shaming all over the world that in a capital of the country a girl was raped at 9 o'clock 9:30 somewhere. Now this was something which was not digested, and there was a massive, I would say massive outbreak of the complete and outcry of the people around, not only in India but outside India also. Lot of NGOs, even the United Nations, women being all wrote to Indian government that these girls should be protected. And there should be some measures taken that the victims, those who are going to girls who are getting victim, they should get justice. Now, after Nirbhaya's case, I remember that then Chief Justice of India, Altamas Kabir, he told in a press conference that he wished he could also be a part of the people who has taken out all the dharnas in the Delhi and all over India also. So he also wanted to be part of the that people where they were supporting Nirbhaya, and they were telling that the culprits should be punished. Such was the outcry of the public that time. Now this led the government to appoint a Verma committee to make some investigation for the reasons why rape were increasing and what punishment should be awarded to this convict, should be given to this convict, those who rape and such culprits. This matter within the Verma committee that time was given 30 days timing. On 29th day, Verma committee made some recommendation. Now this was headed by three people, two were women in that Verma committee. Justice Laila Sheikh, if I recollect properly, and also there was another lawyer, Gopal Subramaniam from the Supreme Court, and Justice Verma. Now, when their report came, they gave so many recommendations. Not all the recommendations were accepted, but few of the recommendations were accepted. And because of that, there was a criminal law amendment in the mostly in the rape cases, and also rape laws, and also the other laws which were against the of the sexual assault, eve teasing, acid attack on the girls. Now this what Burma Committee's contribution to rape laws, which was also known as after 2013 as the Nirbhaya Act, which was like in rape cases the punishment was increased from 7 years to till 20 years. It was made rigorous. Also, there were so many things. The consent of the girls was increased from the age 16 to 18 years. That was the biggest thing. And her consent if obtained forcibly or which was already there in the law. It was also said that if she is 18 years or below 18 years, up to 18 years, her consent was not like it, even if it is accepted, it will not be like what she has, even if she has agreed, it's a love affair and the person has a sexual offense and she makes a complaint, it will be termed as rape. So this was the girls were protected under this law, and the major change it came. I would say previously, what was the definition of rape? It was given in section 375 of the Indian Penal Code, which is the vaginal penetration. But after Nirbhaya's case, there was a Criminal Amendment Act of 2013. Rape laws were completely changed. It was not only vaginal penetration. It was anus was included, urethra and mouth. So any part of the male organ inserted in these parts, four parts. Also, other than that, any private part of a male person touching the woman on any part of her body would be called sexual assault on her, and that was included in rape. So rape was definition was widened completely. So always remember this rape definition was widened completely because of the one reason that previously penetration was only for the vaginal penetration was rape. Now because of this law and because of the technology changing, pornographic websites are available, there has to be rape in some other ways also. So this was the, I would say, a complete change or complete overall in the rape laws, which made it compulsorily that even if the private part of the person, whether there is a penetration or not in a mouth and urethra, anus, or vaginal part, it will be considered as a rape. So rape definition was completely changed. So I see many times some lawyers they say he had put in a mouth, so it is not rape, and some application for discharge was made in one of my case. Then I have to instruct my learned friend on the opponent side who was representing the accused that even inserting pen in the mouth of the that lady is on nowadays. It is a rape because after the amendment of Criminal Act 2013. So Criminal Law Amendment 2013 is very important part. It is available on Wikipedia or also on the Google. Kindly go through the same. And beyond that, there were also some other improvements in these laws. But the main improvement was that there was a punishment which was extended up to 20 years, and also in some cases where it will be life imprisonment, and life imprisonment it meant the life imprisonment, the rest of the life he will be behind the jail, the culprit will be behind the jail. Nirbhaya's rapists were convicted, but and she was murdered also. But what I wanted to tell all of you that if you know rape laws properly, every girl here who is attending today, if she knows the rape laws properly, she will be able to represent the victim lady, the complainant lady, complainant girl, complainant female person properly before the court of law. So it is very important for all of you to read this Criminal Amendment Act. I have told in nutshell also. This Judicial Committee, Verma Committee, has been like I would say, it has created a magic which has changed the complete rape definition in India, in our country. So the rape definition is not just a sexual one part male organ touching the female organ, but it has the divided the definition of the rape. So if you read it, trust me, there will be more rape cases coming forward, because most of the whatever the figures are coming now before us. It is that rape law mostly happens with the known person in the families also, and by relatives also, which are sometimes not reported, and they are just hush hush buried away. If we can bring this forth, then there will be like a fear where a man can even bother a small girl or anybody. There are sometimes rape cases where we see the child the child is the female child is just 8 months, 7 months, 4 months old. So the complete change of these laws has completely changed the whole scenario, and I hope there will be more punishment and stricter actions will be taken. And as a lawyer, also one more thing I would like to tell you. In our country, the main complaint is that why people are not coming forward to complain for rape. The reason is it takes lot of time in the court, and after 10 years, 5 years, the case stands. But now the scenario has changed completely. If you read CRPC section 309, where you will find that there cannot be an adjournment and the rape cases has to be finalized within 60 days. So for filing charges, 60 days are given, and for complete trial, 60 days are given. Yes, very rarely it happens, but as a lawyer, victim's lawyer, we can always point out, or we can always assist the public prosecutor that whenever there is a rape case going on, if you are representing your the female person or the victim person, you can always tell that 60 days, the trial has to be completed within 60 days. And if a trial is completed within 60 days, what will be the outcome, you all know, because witnesses will be available, they will not turn hostile. And when the judgment comes, like if it doesn't come for years over and it comes immediately, there will be impact in the society, and all the 10 people who may even think of raping will think 10 times, because they know that rape laws have become a stricter phenomenon now. So it is very important for all of us to know this criminal amendment act. Also, Nirbaya's case, I would like all of you to read it once. It was very heinous crime, but the way it was dealt by the Supreme Court, the Delhi High Court, and Trial Court, it must be read. There is a lot of from the judges, lot of inputs, and this Criminal Law Amendment Act, Justice Verma's report also. It is also available on the net. If you have time, please go through the same. Now we can also read section 357 of the CRPC, which speaks about the compensation. Now there was amendment in this. Just a minute. (357A) Victim Compensation Scheme. Now, here I would like to tell you, every state government in coordination with the central government shall prepare for a scheme for providing funds for the purpose of compensation to the victim or his dependents who have suffered loss or injury as a result of the crime and who require rehabilitation. Now, 357A CRPC is very comprehensive section. Here you can do one thing. Whenever you are appearing for the victim girl, there are or victim lady, or any witness who has any complainant who has been got injured, and there is some damage to his personal person as a person, or to his limbs, or whatever damage he has, maybe the psychological, also physical, psychological, whatever, emotional, the government provides compensation to them, and every state government has formulated. In Maharashtra, there is a Manodhara scheme which provides a compensation from 1 lakh to up to 10,000, 10 lakhs in some of the cases. So you have to apply. There are two departments here in Mumbai. One is at Chembur, another is Mantralaya. If you find out, so many of the girls who has been raped and they have lost the FIR, they don't even know that they can get compensation. So they can apply. The scheme's name is Manodharya, which is also available on Google. So if you search it, you will definitely find that. So Manodharya scheme, and the lawyers who are here from the other states, I would like to tell, as we have in Maharashtra Manodharya scheme, in all the places also, in other states also, there are schemes which provides compensation to the victim girls, victim females. So if you go and apply, and you take the compensation, the government's treasury will be like empty, and they will know that rape laws has to be become more stricter. So somewhere it will impact the government of the state government also. So please try to take compensation and guide people. Many of the laws are not aware that once the FIR is lost under 376, whatever the consequences of the trial, whether convicted or acquittal of the accused, the lady who lost the FIR under 376 or some other cases, maybe 376D and other matters are also there, maybe acid victims also, they can get the compensation from the respective state government. So please try to get that also. So this was one very important part of the today's lecture. Now we'll ask Vishnu to read for today. Vishnu, can you unmute yourself?
Yes, ma'am.
Just a minute, I'll share. This is an article available on the net. I found it very useful. The difference between Article 226 and 227 of the Constitution of India. Normally, we find both the articles applied on the whenever we file writ petitions or any application also when a 482 is also filed. So, what articles has to be applied? This is what we can understand from this article. So, you can start from here. Vishnu, kindly continue.
Yes. Article 226 and 227 are the parts of Constitution which define the powers of the High Court. Article 226 empowers the High Court to ensure to any person or authority, including government, in appropriate cases, directions, order, or writs, including writs in nature of habeas corpus, mandamus, prohibition, quo warranto, certiorari, or any of them. What are these writs? Habeas corpus. A simple dictionary meaning of the writ of habeas corpus is writ requiring a person under arrest of illegal detention to be brought before a judge or into court, especially to secure the person's release unless lawful grounds are shown for their detention. Mandamus, a writ issued as a command to an inferior court or ordering a person to perform a public or statutory duty. Prohibition, a writ of prohibition is issued primarily to prevent an inferior court or tribunal from exceeding its jurisdiction in cases pending before it or acting contrary to the rules of natural justice. Quo warranto. This simply means by what warrant. This writ is issued to inquire into the legality of claim of a person or public office. It restrains the person or authority to act in an office which he or she is not entitled to, and thus stop usurpation of public office by anyone. This writ is applicable to public offices only and not to private offices. Certiorari. Literally, certiorari means to be certified. This writ of certiorari can be issued by Supreme Court or any High Court for quashing the order already passed by an inferior court, tribunal, or quasi-judicial authority. The High Court is conferred with this power under Article 226 of the Constitution of India for enforcement of any of these fundamental rights conferred by Part 3rd of the Constitution or for any other purpose. Article 227 determines that every High Court shall have superintendence over all courts and tribunals throughout the territories in relation to which it exercises jurisdiction, except a court formed under a law related to the armed forces. The High Court can, under Article 227, call for returns from such courts, make and issue general rules, and prescribes forms for, for regulating the practice and proceedings of such courts. Prescribe forms in which books, entries, and accounts to be kept by officers of any such courts. Settle tables of fees to be followed to the sheriff and all clerks and officers of such courts. Scope, powers, and difference between Article 226 and Article 227. The Honorable Supreme Court, in the case of Surya Devi Rai versus Ram Chandra Rai, relied on several constitution judgments of the Honorable Apex Court, on which was Umaji, Keshav, Meshram, and others versus Srimati Radhika Bai and another, which laid down scope and power and differences between Article 226 and Article 227. The first and foremost difference between the two articles is that proceedings under Article 226 are in exercise of the original jurisdiction of the High Court, while proceedings under 227 of the Constitution are not original but only supervisory. Article 227 substantially reproduces the provisions of Section 107 of Government of India Act 1915, accepting that the power of superintendence has been extended by this article to tribunals as well. Though the power is akin to that of an ordinary court of appeal, 8, the power under Article 227 is intended to be used sparingly and only in appropriate cases for the purpose of keeping the subordinate courts and tribunals within the bounds of their authority and not for correcting mere errors. The court further observed that the power under Article 227 shall be exercised only in cases occasioning grave injustice or failure of justice, such as when, first, the court or tribunal has assumed a jurisdiction which it does not have. Second, the court or tribunal has failed or to exercise a jurisdiction which it does have, such failure occasioning a failure of justice. And third, the jurisdiction will tantamount to overstepping in this case of Surya Devi Rai versus Ram Chandra Rai. Further observe that there is a lack of knowledge of distinction between understanding of Article 226 and 227, and hence it is common custom which lawyers labeling their petitions as one common Article 226 and 227 of the Constitution, though such practice has been deprecated in some judicial pronouncements. After reeling on the catena of decisions of the Apex Court, the Honorable Supreme Court in Surya Devi Rai versus Ram Chandra Rai laid down the following differences. Firstly, the writ of certiorari is an exercise of its original jurisdiction under Article 226 by the High Court. Exercise of supervisory jurisdiction, Article 227, is not an original jurisdiction. And in this regard, it is akin to appellate, revisional, or corrective jurisdiction. Secondly, in a writ of certiorari, the record of the proceedings having been certified and sent up by the inferior court or tribunal to the High Court, if inclined to exercise its jurisdiction, may simply annul or quash the proceedings, then do not more Article 226. In exercise of supervisory jurisdiction, Article 227, the High Court may not only quash or set aside impugned proceedings, judgment, or order, but it may also make such directions as the facts and circumstances of the case may warrant, may B. By way of guiding the inferior court or tribunal as to the manner in which it would not proceed further or afresh as commended to or guided by High Court. In appropriate cases, the High Court, while exercising supervisory jurisdiction, may substitute impugned decision with a decision of its own as the inferior court or tribunal should have made. Third, the jurisdiction under Article 226 of the Constitution is capable of being exercised on prayer made by on behalf of the party aggrieved, but the power conferred under Article 226, 227, the supervisory jurisdiction is capable of being exercised suo motu as well. The court concluded that under Article 226 of the Constitution, writ is issued for correcting gross errors of jurisdiction. Example, when subordinate court is found to have acted without jurisdiction by assuming jurisdiction where there exists none, or second, in excess of its jurisdiction by overstepping or crossing the limits of jurisdiction, or third, acting in flagrant disregard of law or the rules of procedure, or acting in violation of the principles of natural justice when there is no procedure specified and thereby occasioning failure of justice.
Vishnu, stop here. Vishnu, stop here. We have less time now. Okay, very well read. Now, see, two articles we saw, Article 226 and 227. Both are flowing from the Constitution of India. Now, there is always a confusion in the mind of the people, which article we should apply. So, I have seen people applying both the articles when it is not required. If you have gone through what Vishnu was reading properly, see, Article 226 about the legal and fundamental rights. So if you are exercising anything, you have to file for legal rights, exercise of legal rights, which is violated, or fundamental rights. Then you have to file the writ petition under Article 226. Now, sometimes 227 is applied. See, 227 is always supervisory jurisdiction. It is for, suppose there is an order of the session court, which you have to go and appeal. And you have to feel that the order is impugned order, it is not properly, it is without the jurisdiction, it has been passed wrongly, then you have to apply 227. Suppose there is this charge sheet is filed, then you go for 482 of CRPC for quashing. At the same time, you also want that there should be some order from the Honorable High Court to the lower court, inferior court, which is the word used in this article. So you will be applying 227, not 226. 226 is only for exercise of your fundamental legal rights, in which wide powers have been given to the Honorable High Court. And for the same, you will go, if you go to Supreme Court, is Article 32, which covers the whole of the country. Supreme Court has got ample power under Article 32, that is for fundamental rights. Now, 226 has got more power, sometimes we say, than Article 32. The reason behind that, under Article 226, if you read it properly from the Constitution, you will say fundamental rights as well as the legal rights. And legal rights include everything. And why this legal rights has been exercised, has been given to the power to the High Court, because the High Court completes the complete state land. If I'm sitting in the Maharashtra, it is Maharashtra and Goa completely. Div Daman also, which is under the Bombay High Court jurisdiction. So whatever if Maharashtra government comes up with a law, which you as a person you feel it is violating your fundamental right or it is against your legal right, in those cases you can go under Article 226. But suppose now you have a case in the trial court, maybe suppose it's Andheri court, Bandra court, and you feel there is some order which is filed totally against the law, you can directly, instead of going to session court from the magistrate court to appeal to another trial court. There are two trial courts. There is session court and the magistrate court. You can go to session court, but then you can sometimes approach directly under Article 227 to the Honorable High Court of the Bombay if the matter is in the Mumbai. Now see what happens when you go for 227. It is a supervisory jurisdiction, correcting the error of the inferior courts. So always remember, whenever you are going when filing under Article 227, don't add Article 226 just for the sake of it. Because Article 226 is totally different than Article 227. And this is not that easy, whatever I'm saying, because it will come with experience. So whenever you are filing any writ petition in the High Court, see whether you are filing a 226 or 227, what is required. If you do not know which article to file, which article to mention in your writ petition, kindly ask your senior. Don't apply just for the sake of applying. Sometimes I see 482 read with 226, 227. No, don't do that. We have clarity. If you don't know, ask the people. And simple reason, if nobody is going to guide you, just open the internet, go on any website where judgments are given, even Bombay High Court website, and see what cases are filed under 227, what cases are filed in 226. See the old judgments, you will be guided. Now, today we have, I think, questions from Suvarna. Yes, Suvarna. Suvarna, you can unmute yourself. Suvarna. Yes, yes, you are permitted. On your video, ask. You have to mute yourself. I'm allowed to mute yourself. Try to unmute now. And keep your video on. You can unmute yourself, Suvarna, now.
Bharat problem. Hello.
Ah, good
afternoon,
afternoon.
ma'am.
Yes, yes.
Ma'am, as you said,
video on कीजिए मैडम.
Ma'am.
video
ma'am,
on.
ma'am video on नहीं हो रहा है ma'am.
ठीक है ठीक है. कैसे
Ma'am, I have one.
बोलिए.
Ma'am, I have one question. Ma'am, sometimes due to some enmity or some personal issues, if some female files a false case of rape, so ma'am, in that case, are there any penalties or how is that dealt?
Yesterday we discussed perjury also. See, you can file a case under perjury, 340 CRPC, if there is a false complaint. Okay? That is possible. Giving false complaint, giving false evidence before the court will come under the perjury, 340 CRPC.
Okay, ma'am. Thank you, ma'am.
Okay. Now I'll hand over to Lalita for vote of thanks for today. Lalita, unmute yourself.
Good afternoon all. Everyone wants to say they hate noise, but I have never met a parent who does not want their child to hear noise. Friends.
Yes, we can say.
I have been working with Anita ma'am since last 7 years. She has always tried to share her knowledge with juniors. This internship is an extension of same. Her devotion to this field has made her an advocate on record with Supreme Court of India. Today, at a parting end, I am expressing my gratitude to her for being a torch bearer, for enlightening our journey on legal path. I thank you all, the participants and Vandana for their active participation. Thank you all.
Thank you. Very well done. Thanks. I'll end the meeting for today.